Participants, a very warm welcome. As president of the European Law Institute, it is my great pleasure to welcome you all to this webinar on the GPI Code-Generated Data Principles. In December 2024, the European Law Institute, jointly with the Global Partnership on AI, GPI, before the merger with the OECD, and in partnership with the Centre d'entreprise international de Montréal en intelligence artificielle, CEMAI, has published high-level principles intended to be used around the world by legislators addressing new copyright or data protection rights in code generated in and output. These principles are intended to be of a preliminary nature for such a fast-moving field and neither exhaustive nor final. They aim to balance the interests of various parties involved with or affected by the development or the deployment of Gen AI, generative AI, while fostering innovation and promoting responsible development of AI technologies. These principles are complemented by an in-depth report that explores existing legal frameworks covering the generative AI lifecycle in the European Union, the United States, and Japan. The ELI has been able to prepare these high-level principles thanks to the work of two co-reporters, Professor Alain Strauel of the Catholic University of Louvain in Belgium and Professor Sebastian Schwamberger from Rostock University in Germany, with the support and the engagement of the European Law Institute and specifically appointed ELI's advisory committee. The work has then been further discussed and approved by GPI within the framework of its project entitled From Code-Generated Data to Generative AI, co-led by Professor Christiane Wenderhorst from the University of Vienna. She's also ELI's scientific director, and Professor Kyoko Yoshinaga from Keio University in Japan. Let me thank all the contributors for the work that will be presented today with our wonderful panelists as well. I will present them as we will go along, but let me therefore first mention that the Q&A function allows you to ask questions in writing, and the panelists will then, during the Q&A session, answer your questions orally. But let us first now start with Professor Christiane Wenderhorst, ELI Scientific Director and Professor at the University of Vienna, and then Professor Kyoko Yoshinaga, because both will introduce you to the overall project. Christiane Wenderhorst has been Professor of Civil Law at the University of Vienna since 2008. She's, among other things, a founding member and a past president from 2017 to 21 to the European Law Institute, and as I said, she's the actual scientific director of the European Law Institute. She's a member of the Bioethics Commissions at the Austrian Federal Chancellery and vice president of the Austrian Jurists Association. She's also president of the Humanities and Social Science Division of the Austrian Academy of Sciences for the term 22 to 27. And of course, her research focuses on legal aspects of digitalization, data economy, and further. Whereas Kyoko Yoshinaga from Keio University, Japan, and fellow of Georgetown University, she specializes in AI governance and ethics with expertise in comparative policies and laws on ICT, media, and cybersecurity. As a researcher at Mitsubishi Research Institute, first until 2023, she supported Japanese government ministries and policy and rulemaking people in Japan, especially. Recently, she led compliance and risk management in AI development. She's a member of METI Expert Committee for Japanese AI Guidelines for Business, GPI expert and external member of several companies' AI ethics and boards. So both of them will have 5 minutes to present the project, and I hand over first to Christiane Wenderhorst. Christiane, you have the floor. Thank you very much.
Well, thank you so much, Pascal. And it's really an honor and pleasure for me to have been invited to this webinar. Actually, I have to say that despite the quite grand title of co-lead, my role in this has been rather limited because the drafting has all been done by Alain and Sebastian. So the role which Kyoko and myself rather had was that of advisors of to people giving guidance to this and maybe the reason why I have been invited to this webinar was also because I am of course somehow the culprit behind the topic given that the term code-generated data was originally coined by the ALI ELI principles on the data economy, which was a joint project by the American Law Institute and the European Law Institute. And I had the honor and privilege to serve as the European reporter and was in charge in particular on the topic of data rights. Now, we provided principles for data rights, rights in code-generated data, and other data rights. And this notion of rights in code-generated data, that was proved to be very influential, actually. So it was taken up by various organizations worldwide, including by preparatory documents of the UNCITRAL Secretariat, so the UN Commission on International Trade Law. It's been taken up also by the EU legislator in its recent Data Act and a couple of further bodies and organizations, including it was included in the GPI Data Governance Working Group's framework paper. And the question was, can we extend those principles that were originally developed for code-generated data, just data? Can we extend them to content or maybe to AI itself? That was one of the questions that were really open and that we wanted to answer. Another question we wanted to answer was, can those principles that were originally developed for individual rights, can they be extended or can you use them somehow for collective rights? So, evidently, in particular for the first of those two questions, it was necessary no longer to just focus on data, but also and not only on data law, but also on IP law, in particular copyright law. And this is why the focus and the scope of this project now was significantly different from the original ALI principles. Well, to cut a long story short, and I know my time is limited, so this was really a new question. We didn't know what the outcome would be, so we were really curious to see what our reporters would come up with. They built on the results of the 2023 study that was conducted jointly by the ODI and the APTI Institute, and I see Joey here in the call, who was one of the authors of the 2023 study. That 2023 study made a case study analysis, so that was somehow the basis for the 2024 project. And now that's all I wanted to say in terms of background, just to say thank you so much. Thank you so much to Kyoko it was wonderful to work together. Thank you so much to the reporters, Alain and Sebastian. Thank you so much to the the whole GPI, Samia and Eli teams, and it was a pleasure and a privilege. And with that, I would like to hand over to Kyoko.
Thank you, Christian. Good evening from Tokyo. I would first of all like to express my gratitude to Eli for this opportunity and to Simia for their continued support. As a co-lead of this project, I am pleased to announce that we have developed a set of principles to guide legislators in drafting legal provisions and regulations on generative AI, particularly in relation to copyright and data protection rights in code-generated inputs and outputs. Generative AI has raised significant concerns regarding copyright and data protection, especially in how its inputs and outputs are handled. While these issues have been widely discussed, many aspects remain unclear. To address this, we analyzed existing legal frameworks in the US, the EU, and Japan, and engaged with experts from various jurisdictions worldwide to develop a structured approach to these challenges. A key consideration in this discussion is that copyright and data protection serve fundamentally different purposes. The public policy interest behind the control that copyright grants and the protections that data privacy laws guarantee are distinct. Copyright primarily aims to incentivize creativity and innovation, while data protection prioritizes individual autonomy and the prevention of harm. This distinction means that the reuse of copyrighted content and the processing of personal data must be treated separately under the law. However, when considering how generative AI should be regulated, we must take both copyright and personal data protection into account. While these legal domains should remain separate, there are areas where similar concerns arise. As a result, some of the principles we have developed may appear to overlap with existing personal data protection laws. For countries without such regulations, these principles can serve as a meaningful reference. Even in jurisdictions with established frameworks, they help clarify key considerations specific to generative AI and code-generated content. Bringing together copyright and personal data protection in a coherent framework was particularly challenging. These two areas of law are not only conceptually distinct, but have also evolved separately, making their integration into the context of generative AI a complex task. Despite these challenges, the discussions among experts worldwide have been invaluable in shaping our approach. I believe this is a meaningful step forward, and I sincerely hope these principles will be a valuable resource for policymakers as they navigate these challenges. Thank you so much.
Thank you very much to both of you, Christiane and Kyoko, for this introduction also on, the larger perspective. And indeed, it's quite fascinating to think that the same project tackles both the data protection and the IP rights when, specialists are very different kind of animals sometimes, and to find these types of specialists renewed thanks to Gen AI is something also interesting in the development of the field. But of course, we need now to understand what are these principles and general guiding principles. So it's time now to listen to our two co-reporters, one after the other. And first, I have the pleasure to hand over the floor to Professor Alain Strouwel from the Catholic University of Louvain in Belgium. He's professor of IP law and even more specifically of digital copyright, as well as media and information law. He has authored numerous articles and books in these areas, and he has been also invited professor in many universities. He also recently was fellow at the Weitzbaum Institute for the Networked Society in Berlin. So one thinks about international cooperation, and here we can see that at least the first co-reporter now can show such internationality, which is fundamental when one speaks about IP law. And I'm thrilled to listen to what you have to say to us today. Alain, you have the floor.
Thank you very much, Pascal. It's a pleasure to participate to this discussion, and I'm very pleased that I could conduct this study with Sebastian. We are coming from completely different areas of law, and that has been correctly underlined by Kyoko a minute ago. It's interesting to see the difference in the constellation of interest and public policy objectives behind those two areas of the law. But at the same time, it's interesting to deal both issues together, and that's the advantage of the inherited notion of cogeneration that Christian underlined a minute ago as the main building blocks. And indeed, we adopted this notion of cogeneration, which is of a higher level than the standard notions that we are used to within copyright law, like reproduction or display or adaptation, or in the field of personal data, where the concepts will be processing, retrieval, storage. All those notions have been defined in those two areas of law, and we supervised, we did a study comparing the way the different systems, the US, Japan, and the EU dealt with those issues of cogeneration under the concepts that have been developed within the two bodies of law. So it's an interesting exercise, and we came with a list of 7 principles. I will present the first 3 ones. The first one is about the use of publicly available data. Well, basically, it's a reminder that public available data is not freely available data, or is not legally available data, because there might be rights. And of course, publicly available data that is not protected either by contract or by statutory law, like copyright law, is freely available. That's a reminder of a principle that is, I think, important, because in other areas than the legal ones, people might think that publicly available data is freely available data. We try to come with some principle to assess whether publicly available data might nevertheless and should be freely available. It's a list of some criteria, like whether the use of the data was reasonably anticipated by the right holders covering the copyright owners or the data subject, which have some rights on their personal data. So we came with different principles that are not that easy to apply, taking into account, for instance, socially benefits of the AI application. That should be taken into account. And when you are using protected data to develop, I don't know, a tumor recognition system, it's a different socially beneficial application than in the case you are using images to produce another video, for instance. So we came with a few factors to do this balancing. The level of transparency of the use by the developers is as well something important. If there is no transparency at all on the training data, that might be used as a kind of a burden for proof on the user that it did not steal protected data. That's for the first principle. The second one derived from principle 27 of the ELI principle for data economy that Christian was pushing, and she invested a lot over those years to develop them. So it's directly related to that principle. And we consider that there might be a right to an economic share into profits or the other advantage derived from co-generated input or data. But we are quite prudent. It exists when it stems from a contractual agreement, from a statutory provision. So we want to avoid some claims of some benefits just based on the fact that someone occupied data or possessed data. There is no right in that case. There is just control over data that shouldn't give way to the possibility to claim an economic share of the output of the profits resulting from the use. Then we have a third principle, which are the rights to obtain some remedies when there is an unlawful use of co-generated input. So it's a reminder that it could be unlawful, and it's an invitation to take some precautionary measures. We don't go that far, but we are a little bit more precise, saying that it's unlawful when it's a violation of contractual obligations or statutory provisions. And to Principle 3 as well, explain that in that case, some remedies are available: damages, injunctions, anti-erasure of the co-generated input. And then we have an important C paragraph in this Principle 3. It's in the case there is a kind of merging, when there is a merge of protected data and unprotected data, then we come with a standard for getting either an injunction or possibly an erasure. And that should take into account quite a lot of criteria that I cannot describe here. My time is over. I leave the floor to Sébastien. Thank you for your attention.
Thank you very much, Alain, for this first presentation of the first three principles. And of course, money is always at stake, so the economic aspect is, of course, central. So let's go on now, indeed, with Professor Sébastien Schwamberger from Rostock University in Germany. Sébastien is a professor of civil law, business law, and digital law at Rostock University, and he has worked previously on the ALI and ELI project on principles for a data economy. So, of course, he has seen the generation of the co-generation wording and concept directly, and then was able to go forward with that. So we are thrilled to listen to you too. And so you have the floor, Sébastien.
Yes, thank you so much, Pascal, for the kind introduction, and good afternoon from my side. And it was, of course, a great help that the ALI-ELI principles have been drafted by Neil Cohen and Christiane Wenderhorst, and that we could build up on them. And it was a pleasure to work on this with Alan and all the advisors and see these principles evolve. Today, I will be speaking on principles 4 to 7. Principles 4 and 5a are still on the code-generated input, and then we have the transition to the code-generated output in 5b and especially principle 6. And then in principle 7 is solely on the code-generated output. When it comes to principle 4, the right to information and transparency, which is the principle 4b, the right to information is a key principle or a key right when it comes to data protection rights. Principle 4 should be seen together with the other rights and rather be regarded as a right that enables the enforcement of the other rights of the principles in the first place. For the data subjects, it is often not at all clear whether data is processed and, for example, whether this is being done lawfully, for example, when looking at Principle 3. In this respect, the right to information is not aimed or is not aiming at ensuring that the data subject receives the processed personal data themselves, like a right to data portability, but rather the right to information should enable the data subject to enforce other rights, such as the right to an economic share or the rights arising from unlawful use. Thus, the right under Principle 4 serves the interest to be informed about the data processing and to be enabled to assert these other rights. This right is, as I already said, central in most jurisdictions that have data protection rights, especially the US, the EU, and also in Japan. However, it is also subject to limits and is not available to data subjects without restrictions. Rather, it should not be possible to assert this right if the information of the data subjects proves to be impossible or disproportionate. Ultimately, a balancing of interests is necessary, for example, taking into account whether the data was used or it was data that is publicly available. Principle 4b also contains transparency requirements, but not for data protection rights. But here we have the division that was already mentioned by Kyoko and also Alain between data protection and copyright. But Principle 4b is on copyright and also enables the enforcement of copyrights as seen in the principles 1, 2, and 3. And it should enable that these copyrights are enforced, for example, when it comes to the data that is, or the copyright protected content, or when it's the same. This transparency requirement thus allows the right holders to better enforce their copyrights. For AI, the use of correct data is key, which is the reason why the ELA principles already contained a right on the correction of code-generated data in ELA Principle 22. But also these principles contain a right for correct data, which is the right to rectification in Principle 5a. This principle requires the provider to use its best efforts to ensure accurate personal data is used when training general AI tools and to avoid that incorrect personal data is generated by those tools. Closely linked to the right to rectification is the right to authentic attribution, which was included in Principle 5b and takes up the discussion that has often taken place under the title rights to one's own voice or the rights to one's own facial expression. Accordingly, authors of protected content shall, in exceptional cases to be defined by statutory law, have the right to be adequately credited if an extensive collection of their creations has been used to train a generative AI tool that is able to imitate a creative style. The second part of Principle 5, Principle 5b, thus already leads to the transition from code-generated input to code-generated output, which is addressed centrally by Principle 6, which is the rights to an economic share, information rectification, authentic attribution in code-generated output. It is undoubtedly one of the central problems in connection with code-generated input, and it was discussed, for example, in copyright, where the protected item appears in the output, or in terms of data protection, where the generative AI is able to remember the code-generated input. Principle 6 strikes the transition with the wording that the rights in Principles 2 to 5 should apply by analogy to code-generated output when the code-generated output has manifestly been generated with the code-generated input and the output represents substantially similarities with the code-generated input. Finally, the right to explanation and transparency in Principle 7 goes beyond an application of Principle 4 by analogy to code-generated output. Rather, it enables the person not only to be informed, but also to understand the role of code-generated input and the main elements of the code-generated output. However, this right is also subject to a balancing of interests, taking into account the adverse impact on the person and whether the information can be retrieved from another source. Finally, Principle 7b on transparency of code-generated output makes sure that the output is detectable as artificially been generated or manipulated. So Pascal, I will hand back to you and look forward for the external presenters and the discussion.
Thank you very much. Of course, things are piling up. Now we have code-generated input when you have several inputs to code-generate some data, and then you have the output that might still have traces of the input and the code generation, and one can see how things might become complicated, especially linked to the copyright element, not only, but also, and that's why we thought it would be at most interesting to have with us Michelle Woods. She's director of the Copyright Law Division at the WIPO, at the World Intellectual Property Organization, seated in Geneva. And so Michelle will be able to give us some reflections on these GPI principles and also the WIPO's perspective on the topic, because of course it's a core concern. I can imagine reading also the recent newspapers, including in Switzerland Today, on these issues. So I'm very happy, Michelle, to hand over to you. Thank you.
Thank you so much, and very happy to join everyone today. So at WIPO, we come to these very important topics in the GPAY principles, essentially from two perspectives that are perhaps a little different from those reflected otherwise in this webinar. The first is our focus on intellectual property, and I think we're, in this sense, very pleased to see how central copyright, actually my area of expertise, as well as IP in general, have been reflected. This is not necessarily what we see in many of the other multilateral and global fora where we're involved in the AI discussion. Sometimes it's difficult to get any mention of intellectual property. So our approach on AI and intellectual property mainly consists of fostering dialogue among nations, stakeholders, including AI companies, creative industries, civil society, and trying to foster consensus towards a human-centric, trustworthy, and transparent system in order to derive solutions that can benefit all of those stakeholders. Obviously, that is aspirational, but in terms of what we actually work on with respect to AI and IP, a lot of that does involve dialogue at the global level. So I would note that data is very important and intersects with our work a lot, but our perspective is primarily from the intellectual property perspective. So there are important similarities, but as noted in the principles and in the report, there are important distinctions. In terms of the other perspective I wanted to note, it's our global multilateral perspective. So much of what we have done up to now on AI consists of discussions and dialogue in different formats. For example, about every 6 months, we have conversations. These started off as conversations on a range of frontier technologies, but for the past few years, they've been focused on AI topics, most recently generative AI inputs in one session, outputs in the other. And we do see continuing that there are plenty of topics to cover. Our next conversation will probably be focused on some of the solutions, copyright infrastructure solutions, which is an area where we see that there's a lot more to be brought to the table, and the discussion that isn't necessarily brought in on a regular basis. So we also have in the Copyright Committee, the one that where I lead the Secretariat, information sessions requested by our member states. Information session clarifies that there's no goal at this point, at least, but in general, and with respect to the session, of looking for any kind of normative solution. We are really providing information, exchanging information. We had one quite recently that focused on the creators and their experiences with generative AI, including the advantages for those who are using this new and exciting element in their creative work, and the difficulties that many are running into in this new context, including with respect to remuneration. I noted that the underlying study here focused on legal frameworks in developed economies, and our perspective there is also a bit different because we have a very strong development focus. We have a development agenda that is mainstreamed in a lot of our work, and we are hearing a lot from developing countries about their perspectives, and these are very important voices to hear. I would say their perspectives aren't so different with respect to some of the underlying principles we're talking about here, transparency, accountability, etc. But the emphasis two examples I could note would be control of data, including publicly available data. There's a lot of discussion about making sure that developing countries and regions maintain control over data and data policy, despite the global nature of many of particularly the platforms that are involved, the AI platforms that are involved in some of the activity that's most perhaps concerning to some of the stakeholders. So, and the second theme is really remuneration of creators. We're hearing this needs a more central role, needs to be front and center in the discussion, and that it's very important for developing countries to strengthen the creative economy as a pillar of their development. And they're quite concerned about the impact of AI, and particularly where there may be AI-generated works that would compete with the work of creators. I mentioned transparency as a common theme, and this is absolutely the case in terms of our work and what we hear from our member states, that it's essential, that it needs to be carefully defined and implemented, and perhaps looking at technical systems can help provide mechanisms to get these important principles into place, looking at areas like attribution, potential opt-outs, usage, royalty reporting, and payments. Another area of importance you mentioned that we have seen a lot of discussion about is contractual agreements and how those intersect with the other elements that come into play, including fair use principles. We've done a fair amount of work here on text and data mining, one of the topics that came up particularly in the report. And we have an ongoing project in Africa under our Committee on Development, where we had a real reality check that countries and universities specifically are telling us their issue is right now bandwidth, energy, before we get to any of the sophisticated questions related to text and data mining. So these are the kind of perspectives we try to bring to the table, and we watch with interest as the text and data mining discussions continue, including, for example, in the UK with the latest consideration of that question. So I will wrap up now, but did want to invite all of you to the latest global dialogue we will be launching, which is going to be an AI infrastructure interchange, a forum for technical, practical discussion to enable stakeholders to come together in a safe environment to exchange on and facilitate common approaches and technical solutions for navigating the new regulatory, licensing, and labeling requirements emerging in the AI space. So we hope we'll see all of you there and in our ongoing global exchanges on principles and important frameworks applicable to AI. Thank you.
Thank you very much, Michelle. Thank you very much also for these various points, which in a way resonate with the principles, not only transparency, but also the issues of contractual agreement. And some go really beyond, and the issue of remuneration of creators is, of course, a central one, both for the co-generated input and the co-generated output, and both are of course of central dimension. We might come back to these issues in the Q&A section, and of course I can remind the audience that you can already now put some questions in the Q&A section so that we can then easily answer them during the part of this webinar dedicated to Q&A. We will now continue our reflections and presentations with Christopher Yu. Christopher Yu is the Imazoji Professor in Law and Technology at the University of Pennsylvania at Penn Law, and one of the most cited scholars in administrative and regulatory law and intellectual property. He has authored many books and even more scholarly works. And before entering the academy, Professor Hugh Clark for Justice Kennedy at the US Supreme Court and practiced law with Hogan and Hartson under the supervision of now Chief Justice Roberts. And therefore, one could say that he has all the strings in hand, an understanding of what is needed to be a good judge and therefore of the judiciary, but also what is required in practice, and has the principled-oriented approach that is needed when one is a revert professor. And so, Christopher, I'm very happy that you are with us today, and I hand over to you.
Well, thank you for having me. I'm delighted to be here. I gather that I'm here to bring a U.S. perspective, and I'm particularly delighted to be part of this because I was not only a member of the Board of Advisors, I was involved in the ALI Principles for Data Economy Project. I was actually, in addition to being on the advisors, was then engaged as a consultant and helped draft some of the commentary, and so I'm glad to see all that work bearing fruit. I will confess in advance that my first involvement with this project was 2 weeks ago when I was invited to make this presentation. So I'm not as familiar with this long-term development. So I take the documents sort of on their face. And so, but that's not an inappropriate perspective because people who read the documents, that's how they'll come to them. And I apologize in advance if I miss any of the nuance or some of the more complex issues underlying them. So just leaping in, trying to understand how I can contribute the most to this conversation from a U.S. perspective. There's some issues. I wanted to make sure that to clarify a couple issues under U.S. law to make sure that you are aware of how it plays, but in addition to report on some interesting recent developments which may or may not have reached the consciousness of European and foreign international observers. I find that in general, of all the principles that I look at, the one that I confess that rivets me the most and I find the most engaging is principle number 1. The report that summarizes U.S. law characterizes this as U.S. law not having a great deal to say about publicly available data. And it is correct that U.S. has no omnibus privacy law, and that under most state laws, the relevant ones, they mentioned 2, there are now 20 of them. Publicly available data is not subject to any constraint. There is one area of law that makes that a bit of an exception that's flying under the radar, and that's something called the Computer Fraud and Abuse Act, which is really an anti-hacking statute. But it has criminal penalties. And one of the more interesting phenomena that's happening right now is social media sites are including in their terms of reference forbidding the use of public scraping of publicly available data. And the CFAA is triggered by exceeding authority of usage of data, and that's really the classic sort of fact pattern. Is there an employee who's authorized to use it for certain purposes but not for others? Or even worse, a disgruntled formal employee who still has access that hasn't been cut off. And then the question is that's the classic trigger for liability, which is exceeding authorization. And the interesting question is if a social media site simply puts in the terms of reference no public scraping, is that now exceeding authorization and becoming a potentially criminal suit in addition to civil liability? There is a 2021 Supreme Court decision narrowing this called Van Buren, and a Ninth Circuit decision called Haiku in 2022 that limits it and strongly suggests that this is not going to be subject to liability, as many observers believe. But technically, it still is out there as a potential hook for a potential an ambiguity that still hasn't been fully addressed yet. Just a couple, of the thoughts. The thing that struck me the most about Principle 1 is it proceeds in that unless there's a statutory or contractual bar, information is freely available. And that struck me as a big, quite difference from GDPR, where in fact you need some affirmative basis for processing, and that if in the absence of it's essentially requiring opt-in consent, where the default is unless there's a clear basis, often contractual under consent, that you cannot actually process the data. Here, it's sort of the reverse, which is unless there's an affirmative prohibition, that is, you can use it, as opposed to unless there's affirmative permission, you can't use it. Now, there are other legal bases under GDPR aside from consent. In a wide variety of contexts, there's jurisprudence about the limitations of it. But it does strike me as a more permissive world in principle. I did find an ambiguity in principle 1 between A and B, where it says A says it's freely available, and then B puts conditions on which it's freely available. And then I found that the relationship between those two provisions left me unclear exactly what the purpose, how they would interact with one another. The other piece of news I wanted to report to you, which I think would be particularly, it might not have reached across into international context, is that there has been a recent Supreme Court decision in the copyright space on the use of AI, which is a decision called Thomson Reuters versus Ross Intelligence, basically declared that certain uses of data to train an AI system were not fair use. Now, what's interesting on the copyright side, as the report correctly points out, unlike privacy, where there's general permission in US law for use of publicly available data, CFAA notwithstanding, that's not true for copyright. Everyone's been relying on fair use and looking at the Google Books decision. This decision really it's on a very narrow issue, and it's on a preliminary summary judgment, and it's just a trial court decision, but it's likely to be extremely influential. And because of it's early, and then because it's a partial summary judgment, it's not immediately appealable, so it will be out there for some time. And what's quite interesting is of all the factors that are listed in Principle 1, they do look at the nature and scope of the use and the traditional fair use factors in the US. But the dominant issue is the fourth one identified in Principle 1B, which is whether then the output is a substitute for the input. And that became the dominant criterion because it was done by a company that was essentially looking at the West headnote section of judicial cases. So we're lawyers, we all can understand this, and essentially creating a competitive product directly off of those notes through AI. And that became there was a 2-2 split in our factors, but under the first and the fourth factor for fair use, the dominant criterion, and controlled the opinion. And so what we'll see then is, when I look at lists like in Principle 1B of 8 rights, you want some form of prioritization. It would appear under US law that factor 4 is in these early cases, the dominant consideration that controls a great deal of the others. My time is running up, but just a couple of interesting things I would throw out there just quickly. I think the Principle 2 on the economic share only by contract or statute, I think is particularly welcome. I think that this is going into the larger question about whether, in fact, we should be thinking about data in terms of property terms or in contractual terms. I think this is helpful. I do concern, in terms of the rights to object and the right to report. There is a compliance aspect of this. A lot of AI is trained on data where you don't know whom to report to and don't have great ability to track those. I think that those may be more burdensome than we might think. The other thing that's sort of in there is the question of whether you have to strike data, whether you have to scrub the algorithm as well. It's been discussed under the terms of, this shows up in Principle 3 and report in the report. The FTC talks about this as algorithmic disgorgement. That was a particular interest of former chair Lina Khan of the FTC. Whether that will persist her stepping down remains to be seen. But I was particularly interested to see in Principle 3A really looking at the harms of retraining and the environmental impacts of retraining as an interesting consideration, a way of framing this which hadn't been there really before. And then the last point I'll make is I found myself pondering the notion of rectification, which is if the data is only being used for inference at the large-scale predictive level, ideally, individual errors in any one record shouldn't be particularly influential in terms of the overall output. We can talk about, there's a number of computer science techniques we use to actually understand that influence. But the burden of rectification, particularly if it involves retraining, is of significant cost and, in my mind, of uncertain benefit, both to the data protection interests of the subject, but also in terms of the overall performance of the algorithm. And so I find myself, when I looked at that, another area where I would be personally have questions about the balance of benefits. And with that, thank you for including me in this discussion.
Thank you very much, Christopher. That's very useful, and I'm sure everyone is already trying to get hold on the cases you mentioned in order to you know understand even better the implications also maybe on this side of the Atlantic. And indeed, rectification is something, of course, that comes back from the data protection perspective. And the issue might also be whether it's a one-time use or whether it's a long-term use, and that might also have an impact. But I'm sure the co-reporters will come back on that. But before, we will have now our last panelist for today, Joe Massey. Joe Massey is a senior researcher at the Open Data Institute, ODI. Joe leads the participatory data program at the ODI, and more broadly, Joe's research has primarily focused on data stewardship, including defining responsible data stewardship and exploring bottom-up data trusts for climate actions. Joe joined the ODI in 2020 and was previously a trustee at We&I, which focuses on raising public awareness about AI and its impact. And therefore, we are thrilled to have a different perspective yet again, a different one, on these principles. Joe, you have the floor.
Thank you very much. It's a real pleasure to be here today and to be surrounded by so many people who've also spent quite a lot of time thinking about cogeneration. So really happy to be here today. It's also particularly timely, as Michelle mentioned, as the UK has is just wrapping up its copyright consultation around AI, and so much food for thought and much speculation here in the UK about what might happen next. So the Open Data Institute is a research institute based here in London in the UK. And we do a lot of action research. We try and bring a lot of these topics and theory and really apply them and ground them in the realities of the day-to-day in the data ecosystem. And so as a way to kind of interact with the principles that have been discussed today, I wanted to share a little bit about the 2023 work that we did with Ji-Pei and Kyoko and Christian, which looked at cogeneration through a series of 6 case studies. So working with the APTI Institute that is based in Bangalore, India, as well as Pinsent Masons, we focused on trying to understand what different rights and legal frameworks applied to cogeneration scenarios in different settings, looking at kind of things well covered in the first sets of principles like cogenerated data, as well as cogenerated technology and AI cogenerated works. And so we're building on lots of the fantastic work that's been done by many of you here on this webinar today. So across these 6 case studies, we looked at things like remunerated work, so data labeling. We looked at collaborative crowdsourced data collection, Internet of Things, social media platforms, and of course, generative AI, which poses a lot of interesting questions in this space, hence the work by many people here. We were really kind of deliberate in our selection of using case studies for this work and attempting to bring this fantastic work on principles to life and to look at 6 examples where cogeneration is happening and trying to understand what that actually means for the people involved and the organizations involved in those different scenarios. So for some of the scenarios, like crowdsourced collective mapping, things like OpenStreetMap, for example, where people can come together and co-create this map. The legal rights are fairly straightforward as people sign up to a series of terms and conditions, and it's kind of people know what they're signing up for to some degree. Another example in remunerated work in data labeling, we looked at Caria, which is an ethical data labeling company based in India. And as we know, data labeling is a real crucial part of training AI models, and essentially tagging data, images, videos, such that the machine can learn the meaning behind what those things are. But it's really kind of quite an opaque industry, and it's often outsourced to organizations, initiatives in the global south with very poor labor standards and working conditions. And so in those cases, there's kind of very limited rights around data that we found. Finally, I just wanted to touch on the into AI cases where we looked at Whisper AI, which is an OpenAI audio model, and Midjourney, which focuses on imagery. And so we know that there's kind of significant uncertainties around the creation of these models themselves, thinking about the data that goes into the training data sets, as well as the outputs, which have already been discussed by many people on the call today. We know as well that there's a lot of fragmentation across different jurisdictions, and I think it'll be great to discuss kind of what that means in going forward, given the US's kind of push towards a very permissible regime and a strong emphasis on growth, and a lot of the kind of development happening there in the US. We're really interested to see what that means for other countries going forward, and copyright and data right regimes in different places. So what we found from this research is that in practice, code generators are subject to a real complex web of different rights, but there are still quite a lot of gaps in practice. So I think that's where we found the most difficulty, is that where there are rights, in a lot of cases, it can be quite difficult for people to actually exercise them in practice. So we found examples where rights are set out under terms and conditions. However, there's quite a lot of scholarship detailing how consent is really informed when using these processes. So there's a lot of scenarios where we need to kind of better think about the ways that people can enact these rights that are kind of embedded in the principles that we've been discussing today. We found a lot of kind of discussion around whether code generators should have rights in different scenarios, and I think the work by Sebastian and Alain moved that conversation forward through the principles, kind of deciding in which scenarios these rights should be attributed and not. But where we do decide, there's many different factors to think about in kind of level of involvement in code generation, awareness of code generation, how much harm and financial gain have been made, and thinking about the different level of contributors. So thinking about what that means in generative AI, it's actually particularly difficult use case, and kind of hence Christian and Kyoko's desire to kind of move the conversation along from code-generated data in its own right. So as I think it's been really great to hear a lot of discussion today about transparency, something here at the ODI, which we're really, really big on, as you might guess, by the name Open Data Institute. And we've recently been working on an AI Transparency Index, which looks to try and understand how different AI models, how open they are around data. And as you might guess, it's not particularly good news. So in a lot of cases, data from generative AI models is not disclosed. Training data sets are made up of huge amounts of different sources. And so data is coming from lots of different places. And the volume is absolutely enormous, which presents plenty of different problems, particularly as Christopher mentioned about going back and making changes to models that have already been trained. And so to kind of wrap up my section here, I just kind of wanted to kind of bring that back to the panelists and to kind of present some challenge in thinking about what does all of this mean in practice. So, you know, we've discussed a lot of kind of really meaningful proposals for rights in the digital economy. But how can we make that happen in practice? So here in the UK, there's a lot of interest around opt-out for generative AI training data sets. But there are naturally huge complications in how this might work in practice. And as to Michelle's point, we need a lot of more work on the infrastructure that will enable these types of approaches. And so really excited to see what ideas the panelists have in this regard. We've focused a lot naturally on copyright and data rights, but really interested to see what other rights that might be appropriate to support code generators in this case, and in particular with collective rights, which is something that we talked a lot about in our report. And then finally, as a kind of non-legal expert myself, I'm really interested in some of the other options that are out there beyond legal mechanisms to support code generators. So we think that there's a real need to experiment further around bespoke data licenses, new forms of data governance, and exploring other mechanisms for kind of redistributing the financial gain from the innovation using code-generated data and works. So that was everything from me. It's been a real pleasure and looking forward to the questions.
Thank you very much, Joe, for this wonderful list of questions and further food for thought. We will now start a Q&A section. We have more or less 25 minutes to half an hour to answer any questions the audience might have and also further questions. I thought I would start with Alain, maybe also to give him a chance to react on some of the remarks that have been done. And of course, Sebastian, you can also then add your own views on the various aspects. Maybe to lead the question to you, but you are free to answer whatever you want then. One aspect I think was also underlying the various remarks was the issue of transparency by design and the issue of compliance. So you have a transparency requirement, but then how do you ensure compliance with it? Is it through, could it be through design? What would be the consequences in absence of transparency? Are they similar in case of infringement of IP right? And in case of violation of the transparency requirement, or would you see differences? So maybe these are two things that I would just throw to you and lead maybe a first round of reflections you got after the first round of panelist talks and presentations. Alain, you have the floor.
Well, thank you, Pascal, for asking the question. I would like to thank all the contributions and the comments that we received. They are obviously helpful, and there were quite a lot on this principle one by Christopher, for instance, but you come back with the issue of transparency that is in Article 1B. So first of all, yes, we could not take everything into account, including the very interesting Thomson versus Ross Intelligence decision that, of course, I read, but that was this month, and we finished the work a few months ago. And I'm very pleased to hear that it might be an influential decision. That was the comment of Christopher, even if it's a summary judgment. But it's very interesting to bring forward this issue of the fourth criterion of use, that is the impact on the market. So whether there is a substitution effect or not. We have tried to include it indeed, that notions, and it's in principle 1B5, 4, whether there is a good substitute with the output versus the input. I think that will be a leading factor for copyright, at least. The notion of transparency and the requirement of transparency that should be taken into account to assess whether publicly available information is freely available, I think will require rules to details how far these transparency requirements can be put into practice. As you know, in Europe, we have the AI Act, which contains in its Article 53 some already a little bit more developed requirements concerning transparency of the sources used to train AI tools. And the next stage will be the codes of conduct that are in the process of being finalized to detail what kind of information will be required from the developer of Gen AI in order to be transparent. I think with these codes of conduct on how to be transparent with your sources, we will have something that could serve as a basis for a common discussion. I hope so, at different levels. At least it's an attempt from the legislator and then from interested parties participating to the elaboration of the codes of conduct to come with something that is more precise than just referring to transparency. We could not go that far, but as I said, I think if some Gen AI company or developer or user or provider in our terminology does not at all respect these requirements of transparency, I think concerning then the unlawful use, there might be a strong burden of proof against those which do not engage with the issue of transparency. And that's what we meant.
I see. Thank you very much, Alain, for this first answer. I don't know, Sebastian, do you want to also to react on one or the other point that was mentioned before by panelists?
Yes, of course. At first, thank you all for the feedback, and I would also like to come back on Christopher's. Yes, they were very valuable. What you said, especially what I noted, what needs to be clarified is the relation between principle 1A and 1B, which is not 100% clear. And this is I just wanted to mention first that these principles are not final yet. They are a very finalized draft, but they are of a preliminary nature. And the scope is that they are primarily addressed to legislators that are dealing with these issues, and especially when legislators are, and we could be a little more clear, or a bit more precise here, that when a legislator decides to introduce a new statutory provision, he should consider all these factors, or these are the factors that could be considered, but nevertheless, they could maybe also be considered when there's an open contractual clause that leaves a balancing of interest. But primarily, these principles are addressed for legislators, and B should address legislators that are introducing a provision on freely available use or the use of publicly available data. So I think that's the first thing. And what I also noted is on the rectification, and this is of course an issue, and there were a lot of discussion as well on which factors we should introduce in Principle 5 as well. And now we just mentioned that it should be the best efforts to ensure accurate personal data. And of course, it should not be disproportionate, these efforts.
Thank you very much. We mentioned several domestic or national legislators going forward with rules and so on. And so maybe, and that might be a question for Kyoko. We have here general principles, right? And the idea is, of course, to foster a kind of international cooperation. So the principles refer to a statutory provision. Of course, this statutory provision might be international conventions, but for instance, in IP law or GDPR, but they might also be national and domestic provisions. So to what extent and how maybe also can this international cooperation be improved? Do you think that these principles may help to improve the situations, or what should be done in order to make it happen?
Yes, thank you, Pascal, for that question. As generative AI evolves and when we're seeing more and more code-generated works, we urgently need international cooperation on copyright and data protection. First, we must harmonize regulatory frameworks, regardless of hard law or soft law. The regulatory style that each country's take should be respected, as factors like existing laws, societal features, corporate cultures vary from nation to nation. While every country has different copyright laws, global principles like those from WIPO and OECD can guide how AI-generated works are treated. At high level, governments should continue making efforts to establish common principles. And we are already seeing these efforts being made by G7, G20, OECD, United Nations, etc. Second, bilateral and multilateral agreements should address AI-specific challenges. Similarly, cross-border copyright enforcement must be strengthened to tackle unauthorized AI-generated works. Third, we need technical solutions for compliance, standardized AI content labeling, and privacy-preserving AI models can reduce the risk of copyright violations and privacy breaches while enabling smoother cooperation across jurisdictions. And finally, as Michelle also mentioned, the government, industry, and civil society must collaborate through international regulatory bodies and public-private partnerships. AI governance isn't just a legal challenge, it's a societal one. So by working together, we can create a system that protects creators, respects user privacy, and fosters responsible AI development globally. And as a GPay expert, I want to say that GPay is also working hard on making practical guidelines, such as these, principles that we are presenting today, to help making these international dialogues happen.
Thank you very much. I see that the international dialogue is at the center, and here we have people sitting in Japan, in the US, and also in Europe. And if we go back, for instance, to this idea of transparency or transparency by design, right, Kyoko, you said technical solutions might be a way to have harmonization, or but also, of course, the societal change. And probably the understanding of transparency from different cultural and legal background might change. So I was just wondering, Christopher, your understanding of transparency might be also different, or how would you react to what you've heard by Alain and Sebastian linked to this transparency element? Maybe you have a different perspective because the understanding of transparency is also different.
Well, thank you. The U.S. perspective is a little bit different. And actually, what strikes me, I'm glad to have Kyoko here because it affects, Japan's taken a very different approach in use of training data, and it's quite striking. So one of the interesting things to me about transparency is, I do, at the risk of doing the standard law professor thing, I'll say I have an article on this, which is looking at whether general AI can comply with GDPR. And the needs for transparency, the needs for informing people that their data is being used, and the panoply of rights of correction, erasure, all the different things that go along with it, is very difficult for GDPR, for AI. And in fact, having talked, I won't out the particular privacy regulator in Europe, but having talked with them, I mean, they're really struggling to figure out how to make this world in which just throwing more data at a subject of, from a data ocean or a data lake without clear provenance is going to be compliant. So it's not clear, and the Italians are bringing the case, and not, I think, properly so under GDPR, that it's not clear that it complies. But the perspective that's here is to really, something that's often missed is compliance costs, which is all these additional requirements make things more costly. And on the margin, what you're going to see is a lack of investment. And there's a certain level where you say, well, okay, don't you care about data protection? Isn't that important? Well, the answer is yes. But compliance costs invites us to think about an optimal level of data protection, which is just because an interest is important doesn't mean we can incrementally add another and yet another and another requirement on top of it. At some point, when you have the marginal benefit of 101st on top of 100 requirements, at some point it has a balance where are you actually benefiting the data subjects and the interests that you're intending to protect further. And one of the things I found in this discussion of these documents, not on the face of it, but woven in at different places, a willingness to consider the other consequences from a compliance of requiring certain things. So, for example, understanding if you're going to have to retrain data, that's going to be costly, and it's going to have a social impact as well. And I find that thread actually particularly welcome in that it's been absent in a lot of data protection discussions up till now in ways I think are very constructive. And to me, the Japanese lesson I think is very clear, which is they're allowing the use of data for training much more generally without worrying about transparency or these more different aspects, because they struck a different balance. And I find that quite revealing. The other thing about, when I look at Principle 1B, we also have to bear in mind, in a way, when you look at things such as reasonably anticipated uses and the social benefits of the use, 1 and 2, I do worry that we think of law too much from an enforcement perspective, an ex post perspective. That is, that's how we teach through a lot of cases and the like. But to me, we have to think about how things work ex ante, which is most people experience law not as enforcement, but actually how to arrange their affairs to avoid enforcement and avoid problems from arising in the first case. And what struck me is it's hard to know the social benefits of an AI use before you've actually developed the algorithm. And so there's sort of a look back aspect of this, which was, after you develop the AI, you find out the benefits, and only then you find out if the training was proper. That kind of puts you in a funny position. Same with reasonable anticipation of data. One of the things that, there's actually a general concept under some scholars in the US about contextual integrity of the use of data, which makes that very natural. I do find it sort of at odds, for example, with how we do with this in patent law, which is if you get a patent, if you had a particular use in mind, let's say Viagra was developed as a heart drug and it turns out it's extremely useful for erectile dysfunction, it's what we permit that to be uses that weren't anticipated at the time as being conveyed in the right. And so the interesting question that we see generally with AI, almost none of the data used to train AI was created with AI in mind. And this is a characteristic of data, and understanding not just the compliance cost side, but the benefit side, that we have to think about this on a more forward-looking, open-ended basis if we're going to see all the benefits of AI come through.
Thank you very much. That's really interesting. And also maybe the question of how to single out the various criteria of Article 1B, whether some are more important than others. And of course, it's difficult to set it I mean, when you look at it from a retrospective perspective, you have them and then you have to look at the impact. But if you want to be a bit more prospective, then potentially there might be a tendency or a wish to have a kind of hierarchy between all these elements in order to be more prospective oriented. And that might be also interesting. I was just listening to you, and maybe that may lead me to ask a further question to Alain and Christiane. Maybe first to Alain, because the economical perspective that Christopher just mentioned, of course, is a very typical common law perspective, if I may say so, with due respect. And it gets into a difficult area when we speak about sorry. It's terrible. When we speak about IP law, because IP law is, especially from a civilian perspective, is considered as a right, erga omnes, an absolute right. And the idea that this right would suddenly fade out because of economical considerations might be difficult to accept. So we have here probably a certain tension. And I'm wondering whether for data protection, where the absolute right is also there, but maybe less central, at least for some of the data, whether there is a difference in the approach, whether you use data linked to data protection and data protected by IP rights. I don't know whether, Alain, you want to react to this statement and say I'm totally wrong with that.
Briefly, yeah. I think the IP phasing out is not exactly what we are seeing right now. I think there is clearly a push from creators, and I think the debate in the UK show that. It's going maybe in the other direction. So I don't think that there is a risk of the point of view of creators to be forgotten. On the contrary, I think we might expect the tension to raise in the future. And any change of the legal framework is become very difficult for that reason. Well, I mean, to come back on some comments of Christopher. Yeah, I mean, the compliance cost. I completely agree with that issue. But that's why in principle one, we were, I think, more permissive, and that's what Christopher underlined, more permissive in a sense than the existing data protection framework. But at the same time, our proposal might be made compatible because, I mean, he said that we don't have to do any check of the ground for using personal data, legal justification. In practice, based on GDPR, it can be justified to use of personal data for training on the basis of legitimate interests, and that's what data protection authorities have underlined. Well, that means some kind of balancing at the end, legitimate interests. And I think we try to go a little bit further in listing some parameters for this balancing. So I think our proposal in our principle one, which includes B, might be even compatible with this approach. And I must stress, we try to stress the social benefit factor that has to be into account. It's in the first principle. Maybe it should be added in the last principle, including on the right of rectification, where we don't have the same kind of balancing exercise in the way it is formulated right now. But that's something to take into account, I think, so that we can take into account other effects, social effects, and maybe effects on investment, and stressed by Christopher.
Thank you very much. Christiane, maybe Article 2 of these principles link to Article 27 of the ELI data economy, right? The issue of right to an economic share. And I remember when we discussed that in the European Law Institute, it was a primary concern to determine how much we should put weight on the economic share. And it seems to me, and I would like to know whether you agree or not with this proposition, it seems to me that linked to these principles, the economical perspective has increased in playing a more central role, probably because of IP right that was put outside of the scope of ELI data economy principles. Would you say that your concerns initially when you crafted the word and the notion of co-generated AI was more a matter to determine what are the non-economical aspects first to look at, and that now getting into the data protection and IP rights, the economical aspect may grow or maybe become more important and trigger different considerations? Or would you say that this is just going into the same direction that you intended with Article 27?
Oh, thank you so much.
That was a long question.
Yeah, there was a long question. I'm not sure you mean Principle 27. I think you might mean Principle 23, which is
yes,
right to
right,
to an
23.
economic
You're
share.
right.
27
Sure.
about something else. Well, I mean, you already mentioned the basic difference between the original ELI principle and this new project. And a basic difference is the ELI principles said from the beginning, we're not dealing with data protection law as such. We are not going to deal with IP law as such. So what the ELI principles basically did is take a meta perspective and try to formulate principles for that emerging body of law, which is not as strongly visible in all regions of the world, I have to say, but which is emerging everywhere, and which you could call data law, which is somewhat in between data protection, which is specifically for personal data, and IP, which is a very specific subject. So that is, of course, a very superficial answer. Having said that, I think the ELI principles already take a quite economic perspective. It's just that Principle 23 doesn't exactly come to the same conclusion as Principle 2 of this project now. I mean, the basic rule is the same. The basic rule, both in Principle 23 of the ELI principles and Principle 2 of those principles, is that you say, okay, normally there should be no right to an economic share just because your data has been used at some point. And normally you should only have a right to such a share when you have either a contract to that end or you have a statutory provision that gives you that right to an economic share. So the basic rule is the same. The real difference which I see is that these principles, as Alain said in the beginning, are more cautious because they take this data protection and copyright perspective. They're more cautious and they stop at that point, basically. And we were a little bit more courageous because we were dealing not specifically with data protection and copyright. We were dealing with that in-between category of data law. And we said, well, there is one exception, and this is in very exceptional cases when three requirements are met. First, that a party's contribution to, as you would say, the co-generated output was really unique. You know, you couldn't have substituted it by anything else. It is clearly recognizable. It's absolutely unique, like the artistic style of a painter, or that party made significant investment in it. So that's the first criterion. The second one is that the profits derived are really exceptionally high. And the third criterion is that there was no way for that co-generator to have a fair bargain and to bargain for remuneration for various reasons. Now, the situations we would have, I mean, the original paradigm case was the Henrietta Lacks case in the UK, in the US, right, with those exceptional cells which Henrietta Lack, who unfortunately died, but her cells kind of created that unique contribution to science worldwide. But you could extend it to other cases. You could say, you know, the artistic style of a painter, as I said, you know, somebody has a very significant, unique artistic style. It's copied by a generative AI and reproduced, and the provider makes millions and billions of dollars with it. So that would be a typical situation where our Principle 23, Para 2, would potentially kick in. Another principle, and this is why I was talking about collective rights, and I'm really grateful that Michelle was mentioning this global dimension of developing over the global south and so on. You know, what if you know, take those generative AI models that are trained on indigenous languages, and you have that unique contribution of the Maori population, and then it is used by the provider of a chatbot to produce a Maori chatbot, which is then again resold to the Maori population. So these were the kind of situations we had in mind, and we simply took a different policy choice as to those situations.
Thank you very much. That was certainly very useful. And maybe I could ask a last question, because time is going quickly, to Michelle, maybe in reaction to what Christiane said, but also there are in fact two issues I see that might be not conflicting, but in parallel. One is the right to an economic share, as expressed by Christiane. The other one is the disgorgement principle linked to unlawful use of and infringement of IP rights. they might be identical, they might not. How would you see the problem on a more global perspective from your WIPO perspective, Michelle, in that respect?
So very interesting questions. I think one point I would note is disgorgement and getting some kind of reparation or action after the fact is extremely difficult. So I think our advice would be to try to start with addressing the question up front rather than trying to fix it after the fact. That's easier said than done, I know, but it's also very difficult to go back and reverse what's been done. And that is not only because of just reluctance of people to give up money, for example, once they have it, but for practical considerations. We've all heard all of these scenarios where metadata, machine readable data, whatever, get erased as data is worked with through different iterations of the AI and generative AI process. So it may just be, in practical terms, extremely difficult to trace backwards in order to figure out how to undertake any kind of disgorgement or after the fact remuneration. So building it in from the beginning would be far more practical from our perspective, even though that's not easy either. But the second approach would probably be more difficult. So, and we have been hearing discussions about collective solutions in the copyright context, extended collective licensing, which is something that operates in some areas in Europe. Is that something that could be taken and used in other areas? We've heard some developing regions suggest interest in that. Even saw it in the latest U.S. Copyright Office study, not developed in depth, but mentioned as a possibility. So solutions like that might be something that could be useful in terms of trying to address remuneration from the beginning.
Yeah, thank you very much. And in that sense, you are getting to Joe Massey perspective, also trying to test what is really possible. And we could continue, of course, this discussion for a while, but the time allocated to this webinar is over, so to say. So let me just thank everyone for your input. That has been very interesting and very useful also, because as was mentioned, these general principles will continue to evolve, probably also to be more concretized once more use cases will appear and more maybe also more jurisdictional cases. But thank you very much to the co-leads. Thank you very much to the co-reporters and to all of you panelists who come and bring your thoughts to the table. And thank you for those who attended this webinar. I'm very glad about this collaboration and partnership between GPI, GEM, and the European Law Institute. And who knows, maybe future collaboration will also bring up new ideas and new principles. For the time being, I wish you all a good continuation in your days, and we will stay in touch. Thank you very much.